So whether it's arbitration or litigation or as the case may be, you must always be able to think ahead, understand your opponent's arguments, anticipate and prepare the necessary counter arguments. Then a critical part of arbitration is also client management. Clients must be engaged and informed every step of the way because it's a lot of money at stake, arbitrators' fees, lawyers' fees, experts' fees, so on and so forth. So they must be informed. You must engage them. You must tell them what is going on. So if they understand, for example, you may say there are 5 arguments. Sit down with your client, have a chat. They may say, actually, argument 4 and 5 doesn't work. Let's focus on arguments 1, 2, and 3 only. So you manage expectations, you manage goals, you manage understanding, and you build a better relationship with your client, because honesty with your client is really one of the most important things. Also, while doing this arbitration, and you may suddenly there may be a chance of a resolution. So you must have some appreciation of how to negotiate and resolve disputes, and that's critical. If you don't, you're actually doing a disservice to your client. Now, the other things which I think are important is this. You must be able to adapt, be dynamic, you must be able to change strategy midway, you must be nimble, as to how you think. And this is one of the great skills of lawyers, because sometimes you may have a fight. I mean, recently, Taya and I had a huge fight in court. We were fighting on different points. He agreed, I agreed, and so he took a particular point I disagreed with, and he was nimble. He was trying to work around the trap I set for him, and I was trying to work around the trap we set for each other, and that's fine. That's our jobs, and that's the way. That's what litigation is about. We anticipated each other's arguments. We fought. Somebody had to win. Somebody had to lose, and life goes on, right? And that's what it is all about. But to do that, you must know your work. You must know every case in the bundle. You must know every case in your opponent's bundle. You must know that what tricks your opponent is trying to pull. And at a sophisticated level, the tricks are the angles which are taken, the points which are taken are more sophisticated, and you must understand the law even clearer, because you're pitching it at a high level. You're pitching issues and points which many people may not understand. But you must understand your case and understand the law such that you're able to pitch it at those levels, And that's what is important. And you must be able to explain to your client, read the law around it, and so that you can articulate your points properly. Then you must be professional. You must have ethics. This is a matter which you cannot compromise on, right? So these things, standards, the way you treat your opponent counsel, the way you treat the arbitrator, the way you treat your clients, you must have ethics. You also must be professional, the way you dress. You can't turn up in arbitration just because it's not court, you turn up in slippers. And I've seen people do that. It's terrible. It's terrible. You can't do things like that. You must have certain standards. I think most people here are lawyers. So you must have certain standards. You must conduct yourself properly, speak properly. Don't be rude. When you cross-examine with courtesy. If the witness is an irritating witness, just raise your voice and make the point and push the guy down. But generally, you don't have to do much beyond that, because the arbitrator, if you find he should know what he's doing. But if the arbitrator is a guy who's, sometimes you have arbitrators who are maybe not in your favor from the beginning, so they may be a little bit biased, or you think they may be biased. How do you deal with things like that? Or a judge who's like that? You still got to just accept it, smile, accept whatever decision, and move on. That is professionalism. You will win some, you will lose some. You cannot run away from that. 30 years on, I really don't know how many I won, how many I lost, or but I reckon if I were to guess, it's 50-50. And that's the way it is. Because this job is a hard job which we do. There's no guarantee of win or lose. Somebody else is going to decide, but you just put forward your best case which you can. Do the best job which you can, and to put forward the best case which you can. Be detail oriented. Know exactly what you're doing. Read every document. Read every page of every document. Don't leave it to your junior. Don't. If you are going to file a submission, do it yourself.
Was one of his pointers to keep his laptop plugged in? So I guess I'll jump in here. Yeah.
Maybe I can introduce Foo Joon Liang, and while we wait for Sanjay to hopefully rejoin us, I think he's unfortunately experiencing some technical difficulties at the moment. So I can introduce Foo Joon Liang in the meantime. Foo Joon Liang is a founding partner of Gun Partnership, which was established in 2011, and a distinguished arbitration specialist. He is a fellow of the Chartered Institute of Arbitrators, Singapore Institute of Arbitrators, and Hong Kong Institute of Arbitrators, and has served as past chairman of the Chartered Institute of Arbitrators Malaysia branch. He is on the panel of arbitrators and adjudicators for the Asian International Arbitration Center, Hainan International Arbitration Court, and Securities Industry Dispute Resolution Center, and is a member of the ICC Malaysia Arbitration Committee. He is recognized by Who's Who Legal for his expertise in high-value construction disputes, and is ranked by Benchmark Litigation and Chambers Asia Pacific in construction-related dispute resolution. In recent years, his work has focused on engineering incidents in construction, including high-profile cases like a hill slope failure in Penang and a bridge collapse in the Klang Valley. So, Junliang, if I can invite you to say share your thoughts on the essentials of advocacy in arbitration.
Thanks, Taya. Good evening, everyone. What Taya read out was what I wrote for myself and asked him to read out. So take it with a pinch of salt. What I propose to do is to spend my 10 minutes dealing with two particular aspects of advocacy in arbitration. The second, taking it in reverse, is what we typically know as advocacy, being suave, persuading the tribunal. But the first is something that is commonly overlooked, which is equally, if not more important. It is the processes and the procedures that are within our arsenal in an arbitration process. So I deal with the first aspect. As Sanjay started out by saying, the difference between arbitrations and in court proceedings is that we are not shackled by any known processes or procedures. As much as the arbitrator is the master of the procedure, he's very much guided most of the time by counsel of both parties. So between parties, you can agree quite a bit. And if there is no agreement, there are certain applications that you can make or certain procedures you can suggest that might further your client's interest or mitigate the problems that your clients face. So when I deal with this first aspect, what I'd like to start by impressing upon all of you is this. In an arbitration, we start with a white piece of paper. We don't have the rules of court. On a white piece of paper, we decide something as elementary as whether we want pleadings or whether we're happy to go with the notice of arbitration and the response to the notice of arbitration for something elementary. If it gets more complicated, for those of you who've been involved in arbitrations, you get memorial style arbitrations where the heavy lifting is done up front. So you have your pleadings accompanied by core evidence, documentary evidence, by witness statements, and also by authorities. So in that one document, you and I commonly refer to as a pleading, what you will have is essentially your entire case laid out. So that's another option in the opposite extreme. Moving forward, the production of documents, how documents are to be furnished to the tribunal, whether oral evidence is to be led, in what sequence. All these are matters which parties can chart by their agreement, or without an agreement of the other party, you can persuade the tribunal that this is the more efficient way to go forward. Now, with that, what I'd like to bring to your attention is two fairly recent procedures that have come to the fore. And I don't take credit for this. Taya brought this to our attention. The first is the Kaplan opening. It is a procedure In as much as it sounds like an opening statement of some sort, it is not. It is a way in which proceedings are opened. And by opening, I mean two things. One is the introduction, opening and introduction of a party's case, and the second, perhaps a more accurate description of the Kaplan opening is that a party's case is opened up for review. So what happens in a Kaplan opening is this: before your hearing, before your formal hearing, right at the end of proceedings, what you have is a face-to-face dialogue between in the presence of the arbitrator or the panel of arbitrators. Now, the idea of that process is for each party to give an opening address, an opening statement of some sort, present typically the evidence that is available to them, the approach that they take to their case, what are the authorities in their favor. So both parties will do that at an early stage before the formal hearing. And once that is done, what the tribunal will be able to see is, of course, the relative strengths and weaknesses of the case of both parties. Aside from the tribunal, I think everybody else in the room will be able to see. Now, some of you may have experienced this. We fight long and hard in the preparation of our case, but on the first day we show up either in arbitration or in court, a lot of concessions are made because we then realize that the witness we thought is going to come to give evidence in our favor isn't so helpful, or the document we thought is heavily in our favor turns out to be qualified in very many ways. But now we're at the door of the hearing. Now we are at the door of the hearing, and we then realize that there are certain concessions we have to make. So the Kaplan opening accelerates this process to the fore of your dispute resolution process. Perhaps after the pleadings have concluded, after witness statements are done, both parties are able to appear before the tribunal. And it helps the tribunal understand the case, and it forces the tribunal to take cognizance, to read up and take cognizance of what the position of both parties are, because otherwise the tribunal will not be in a position to understand what the issues are. Right? Now, what are the benefits of this Kaplan opening? Of course, there is what I've mentioned, an early case review. So before your hearing even starts, sometime before actually, both parties will know exactly where they stand in terms of merits. They will know their case, the weaknesses and the strengths of their own case. That gives them a clear understanding of where they will head with their case. In a typical construction dispute, you will have claims, you'll have counterclaims. So this process allows parties to perhaps put in perspective what the numbers are. I may have big numbers in terms of my claim. Part of it may not be sustainable. Whereas there are counterclaims that are against me. I've got to measure that against my own claim and see whether I will come up on top. If in my analysis, whatever claims I have will be wiped out by the counterclaims, then shouldn't that be a red flag for me to perhaps broach a settlement or offer a settlement? Or perhaps if I realize that the net result in the same situation, I realize that the net result requires me to pay the counterparty, I may make a without prejudice an offer without prejudice except as to costs at an earlier stage of proceedings rather than to wait until the hearing has started. And once this is done, the tribunal can then engage with parties and say in quite a bit of frankness, having seen the evidence, look, Taya, you've got 3 heads of claim, but really, is there anything in the third? How are you going to prove this? And likewise to the other party. And what comes out of that? Typically, again, in a construction dispute, each head of claim will have quite a bit of documents. Aside from documents, you've got expert evidence. So from my little experience, loss of profits. Loss of profits is quite often the biggest chunk of a claim or a counterclaim in a construction dispute, because the sky is the limit. It really depends on the imagination of whoever is couching that loss of profits claim. And when In one of these Kaplan openings, in preparing for one of these Kaplan openings, you discover that your documents aren't great, the law isn't very much in your favor, or the evidence is quite airy-fairy, then it's a good time for you to say, look, I'm dropping this. And by dropping that loss of profit claim, for example, you can rid yourself of a lot of documents, you can rid yourself of experts, and you can also do away with a lot of sometimes confidential or sensitive information. Because if I'm going to show you my loss of profits, one of the things I've got to show you is potentially my feasibility studies on a project. All right. Feasibility studies on my projects, you will have a good insight into the finances behind my project, my company. That's not something I would voluntarily produce or make public unless there's a clear chance that I'm going to get some money out of it. So that's another advantage. This Kaplan opening also allows the tribunal to focus parties on the core issues, time manage. So there are certain issues which may be more complicated, where more evidence is required, parties can spend time looking at it. And once that management is done, the disputes are streamlined, parties may well be down from eight disputed items to say 1 or 2 disputed items. That will short circuit your evidence taking process, your hearing, and you may find yourself with submissions date closer by. I can't imagine any clients, especially a claimant, who wouldn't want his money early, right? So those are some of the advantages you get from a process such as the Kaplan opening. Now, from my experience, it has not happened. This Kaplan opening has not been practiced very much. But if you sit back, you think to yourself, no reason why it shouldn't. That is one clear example, or one example as to how a bespoke process can be put in place by parties very early on. Apply your mind and come up with a process that helps you, right? Let's look at another alternative. The other alternative, or the other process with a somewhat not more funky name, is called the Gangnam Principles. The Gangnam Principles is not terribly different from a Kaplan opening. It does involve intermediate hearings, but the core difference, I think, in a Gangnam principle situation is that there isn't a record of what is discussed. So for those of us who are familiar with mediation, I suppose it's closer to a mediation where both parties again put forward what their arguments are. There is, or what the evidence is, there is no record of what transpires. And with that, the hope is that the real issues in dispute are uncovered. The real problems, the real reasons why parties cannot resolve matters or are pursuing a claim or a counterclaim can be uncovered. Now, with that process, again, you can streamline the issues in dispute, and with that, the documents that are required. Okay. I don't think I want to spend too much more time on these principles, but I'd like to give you an example. Quite often we think as a matter of theory when we're analyzing our case theory, we've got a good case, only to realize that I don't have a witness to back it up. In court, what you will have to do with the best of documents is to have a witness talk about it on the stand at trial, because we are shackled by procedures, by the rules of court, by the Evidence Act. Not so in arbitration. If you realize very early on that you may not necessarily have a witness in a construction dispute that has long ended, for example, people have gone back to their respective countries, not cost efficient to bring people in for certain points. What you might want to do, for example, is to ask for a documents-only arbitration or an early determination based on documents where the documents are clear. Quantum disputes, for example, where we are measuring items on costs, on rates and quantities. Some of them can be done, in fact, more efficiently without a witness in the room interfering with everybody else. Right? The other extreme, Your client tells you that you've got a good case, something transpired, he observed, he has a number of witnesses who are cogent witnesses, who are reliable witnesses, but there are no documents. You will want to tailor a situation where oral evidence is led. So processes can be tailored, and that's an advantage that we shouldn't give up on when it comes to arbitration, and it's essential when it comes to advocacy. Right now, with that, let me take you to the second part of what I'd like to speak about in advocacy. Now, you would have heard this phrase that advocacy is the art of persuasion. And that's true, but it's not an exact science, obviously. Now, advocacy that works before one tribunal does not necessarily work before another. The thing about arbitrations is that your arbitrator is not necessarily a lawyer. The arbitrator does not necessarily come from a particular trade. And with the movement towards diversity in terms of geographical location, in terms of the makeup of the tribunal, culture, you will have tribunal members tribunal members coming from various walks of life. Now, some of them are obviously more interested in the law, others are more interested in the facts, and the third kind might be more interested in what they think is fair in their own eyes. So you want to pitch. Let me take a step back. You want to know your audience. You want to know who you're pitching your argument to. And once you know, it is only once you know your audience that you can pitch your argument to that particular audience. So from my experience, some arbitrators work better with visuals. Some arbitrators would prefer a witness walking up to the whiteboard and illustrating something on the whiteboard. Other arbitrators are more inclined to taking notes, wanting things to be worded comprehensively in a note for them. So you have various types of tribunals. It is important that you know who they are, who you are appearing before, and you pitch your arguments accordingly. So the best of arguments, 1,000-page submission that is very comprehensive on a lot of details might not necessarily work. One example that I read about just before these proceedings is a lengthy submission on offers and on offer and acceptance in a contractual dispute. Now, you could produce a thesis, but I can't imagine very many lawyers will be interested in that, right? They'll be more interested in what the breach is rather than what constituted the contract. So moving on, I mentioned visual aids very briefly, drawing on whiteboards. This day and age with virtual hearings, now that we're on the screen, we can even illustrate on the screen. And that I've found to be quite effective in construction disputes. The experts can draw on the screen, and we are sure that everybody is looking at the same thing, right? Props in a physical hearing, what can be done is a fabrication of the parts that have failed, for example. Building materials that are defective, building materials that have burnt or caught fire, for example. Quite a bit of these things can be reenacted in the courtroom or in before the arbitrator for as a visual aid. So those are the few pointers I have when it comes down to traditional advocacy, somebody standing up and speaking. But I think what I'd like to end with is something I observe quite a bit: flamboyance. I think quite a number of us, or a lot of us, feel that to catch the attention of the tribunal, we need bombastic words, we need flamboyance. I wouldn't rule out the situation where that works, especially after lunch. But I think in a large number of situations, you pick your arbitrator because of what is upstairs. And if you pick your right arbitrator and he has what it requires upstairs, then you want to pitch it at an intellectual level and not be a showman. So that's all I have, Taya.
Thank you very much, Julian, for that
I suspect
very
Sanjay is back. We
enlightening
should call him
speech.
up.
Yes,
Yeah.
I've heard that Sanjay has rejoined us, and if I can perhaps call on Sanjay to continue with his earlier discussion. Sanjay,
Thanks, Taya. Can you hear me?
I can, yes,
All right, good,
I can
great,
see you as well. Yeah.
excellent. So, sorry about that, ladies and gentlemen. But before I was rudely interrupted by the IT systems in my computer. I was talking about being adaptability and also being nimble. So this is an example of of adapting to the circumstances which you are and being nimble. So I had to move from my computer, which died on me, to my iPhone, which I plugged into some socket or something in my house to get a move on. Okay. So in court, sorry, in arbitration, you will face situations where you are caught out. And that's quite common. I mean, you find suddenly your opponent has thought of something where which you didn't think of, or the witness gives an answer which you didn't expect. What do you do in those circumstances? To avoid those kind of situations, you must understand what questions to ask a witness. Understand your material so that if the witness gives you an answer, you're able to respond to it. What as listening what Fu said, Fu talked about the techniques which are available in arbitration in order to deal with issues, or how to tailor your case. That's one part of arbitration, but the other part of it is the actual advocacy and what you need to know in being able to persuade the tribunal as to your way of thinking or as to your case, persuading the tribunal that actually your story is better than the story of the other side. And that's ultimately what, ladies and gentlemen, you have to do to try to win your case. We are advocates. We are also, in a way, individuals which are packaging the facts, the evidence, the law, and to transmit it to a third party. That's what we are doing. To know that, to tell that story of a third person, you must know it very well yourself. You must know everything about it before you can tell it. So back to what I was saying, you must know your material. Many of my younger colleagues, and people who I encounter outside, they say, "Oh, this job is really hard," and it is really hard. It is long hours. There's no, what's that famous saying? The law is a jealous mistress, right? There's no time for anything else. Really, if you want to do this properly. So as much as I like to say that arbitration may make things easier, or it has techniques which you can use to put forward a case in an easier fashion, before you come to that point, before that first day of hearing, before you put forward the captain's statement, or the retreat, or before any of those things, there's a whole lot of work that needs to be done up to that point in time, and that's what I'm interested in. That's what I want to talk about. So back to what I was saying before the interruption. Please, ladies and gentlemen, understand your case, research and know the law, know the facts, and marshal your arguments carefully so that you are able to put forward an argument which is cogent to the audience. Be able to be analyze, adapt, and have all and every bit of attention to detail. That is critical. Without that, especially in the construction industry, you're going to be you're going to lose out. I just want to end by narrating a story of an experience which I had last year. It was an arbitration where we had some very eminent arbitrators, and everything turned on the interpretation of one clause. It was a soil issue, and it was in relation to what we commonly describe as the foreseeability argument, and how that clause was interpreted. And during the course of the arbitration, because the amounts in dispute were fairly large, my client said, "Look, I think we need to get a second opinion on how this clause works and the law behind it." So I said, okay, fine. So we appointed this third party to senior lawyer to look at it from overseas, and this guy was absolutely brilliant. He looked at it, we sent him the material, he looked at it, and he understood the issue with such clarity, that he could break it down and then explain the essential parts of that specific clause in which the entire arbitration turned on. So sometimes, you see, from the junior lawyer's perspective, you don't see it in that way. You say, oh my God, there are masses of information, there's so many documents, oh, there's EOT, this, that, and the other. My suggestion is take it slowly, understand what is in front of you. But as you do that, pick up on the law so that you understand things until it comes to a level where it really an argument turns on one or two issues only. And when you put forward a case like that, and when you argue a case like that, let me tell you, it's really, really wonderful to do it in that way. Because you're pitching it at the level where 90 to 95% of the issues are actually irrelevant. Everything turns on one issue. So if you can understand your case to that level and know the issue which you need to put forward to make or break your case, or maybe it's more than one issue, maybe a couple of issues, then you have understood your material carefully. You've understood the law, understood the evidence, and understood the material carefully. If you are not able to do that, in my view, all the techniques in the world are not going to help you because your basics are not there. So my advice is, before you look at all these wonderful ideas which you have in arbitration and so on and so forth, you must have in place what I call the building blocks. And without that, you can't even go a venture and discuss what Foo is talking about, which is already at a fairly sophisticated level. Thanks, Taya. Nothing else to add.
Thank you so much. Thank you so much, Sanjay. Thank you very much, Joon Liang. I understand, and I'm afraid that Shannon may be unable to join us this afternoon due to some technical difficulties. We have time for Q&A. Does anyone have any questions they would like to ask? No, I don't seem to be any questions for Sanjay and Joon Liang this evening. So thank you very much for sharing your thoughts, both Sanjay and Joon Liang. It's been very interesting hearing from Sanjay on identifying the core issue in the arbitration and focusing on that issue. And as all of us have experienced, usually any dispute at the end of the day turns on essentially one issue, as Sanjay very articulately informed us this evening. And as Joon Liang said, it's very important to tailor your case, how your case is presented based on the strength of your case. So if you have the documents, but if you don't have the witnesses, then perhaps you can opt for a documents-only arbitration. Or conversely, if you have the witnesses but not the documents, you push for an oral hearing. So these are all very interesting takes, and I hope this has been a interesting session for all of you. And if we can take this opportunity to thank Sanjay and Joon Liang for giving us their insights this afternoon, and for BICAM for organizing this. Thank you.
Taya, my apologies for the interruption.
Yes,
sorry.
go ahead.
My apologies for the interruption.
What interruption?
The one where I disappeared for a while.
Oh, okay. The nimble conduct.
My nimble escape and return.
Okay, thank you. That's
Thank
perfectly fine, Sanjay. Sharifa,
Thank
do
you.
you have anything to add?
To wrap things up, thank you so much to the moderator, Mr. Baskaran, and to our guest speakers, Mr. Joon Liang and Mr. Sanjay Mohan. It's been a pleasure hosting you today, and we hope to see you all at the next BicTok on insurance disputes, as well as the next one after that on AI disputes. So we hope to see you soon, and thank you again for joining us this evening.
Thank you.
Thank you.
Thanks, everyone.
Thanks, Foo. Thanks.
Bye.
Thanks, everyone. Bye.